This is our second section for civil liberties. The first section we covered basics that were in the First Amendment as well as in the Constitution. Now we're going to look at what liberties are that are listed outside of the First Amendment and the Constitution. I've used this term a lot of times before, but here's where it is in the notes for a penumbra. What these are things that are not explicitly stated in the Constitution but are considered a right. Things like right to vote, that may not be written in the Constitution directly, but we can kind of imply with we the people. Or right to privacy, as you're going to see in the Fourth Amendment and as we had with our court cases. Life, liberty, and the pursuit of happiness, where the Ninth Amendment says you're under other unlisted life. So the Ninth Amendment is the biggest one, but it's not the only one with this that you have. So. All right, some people think that the biggest amendment is the Second Amendment because you hear so much on it. But for the first 200 years of our country, we really did not have much about the Second Amendment. And the basic focus was usually on the idea that there could be a militia. Our founding fathers did not trust the central government, and so they said that people could arm themselves for self-harm. The right to keep and bear arms was not the main focus, so was the militia. The NRA, when we were doing interest groups, powerful interest group, this is their main focus. There, we had in our unfunded mandates the Brady Bill, where a lot of restrictions that were done, but much of the Brady Bill was declared unconstitutional in Prince versus the United States in 1997. Before basically recent times, the one major case that you had involving Second Amendment would be the U.S. versus Miller, which if you're a gun collector, you know that this is where they had some of the gun laws that were made in the 1920s and the 30s. Most of this was very restrictive on gun use because of organized crime after Prohibition that emerged. This is why machine guns or Tommy guns are not allowed this time, and this upheld the idea of that they have to be registered. So if you're a gun collector, if it's an older weapon, it doesn't have to have a serial number, but if it is after basically the 1920s, it's supposed to have this. The major case historically that kind of changes this will be D.C. versus Heller. The District of Columbia, which in the 1990s had the highest murder rate in America, they will try to outlaw some individual firearm sales of handguns. The Supreme Court will say they are not allowed to, and this is where the idea for personal use really comes about and is upheld by the Supreme Court. This is also when the focus of the NRA will be that. The Constitution, or the case that you must know that the College Board has, and the reason why is because this is where it's incorporated, the idea then that states must incorporate the Second Amendment is McDonald versus Chicago. Where the Second Amendment is the right to keep and bear arms, the states have to uphold that in there, so that you have. All right, the Third Amendment. A lot of times today people think, the Third Amendment doesn't mean anything. That's just something historical. Our founding fathers were worried about after the Quartering Act and the British. That's why they thought it was so important. Today, it logistically doesn't make a lot of sense in order to house soldiers in individual homes in peacetime, much less in war. We have. But there is actually a lot that stands to it. This is where we can look at the original intent and see where our founding fathers really like the idea of home, and sometimes what's called the castle doctrine. But where it really comes in is when we look at mixed in with the Fourth Amendment. In the Fourth Amendment with search and seizure, there's a different scrutiny level. And there for what we have when it comes to something that is like your car compared to your home. There's a much higher scrutiny of what can be done. I kind of give a little fake scenario or whatever in class where if let's say that a police officer notices that somebody was at my doorstep, they handed me what looks like dollar bills, and I sell them what looks to be a bag of marijuana, and if they then pull the person over right down the road for not making a full stop, they search the car and they found the bag of marijuana. They're able to search the car for their own safety, but if they go to the judge and ask for a warrant, the judge is not going to allow a warrant on just that because the judge will be questioning, how do you know it wasn't oregano So again, the level of scrutiny for the Fourth Amendment is because of this idea of your home that you have. All right, here's a TikTok. We don't have many TikToks for us, but there is actually one that deals with the Third Amendment. All right, the Third Amendment also came up a little bit last summer as when the National Guard was called up from different states and then they were being sent to District of Columbia. That's where it actually made the news some then. All right, usually we think of the Fourth Amendment there with search and seizure. It'll be incorporated in the law, but first the states have to uphold it with Wolf versus Colorado. The case that we went over in depth here is where the exclusionary rule was incorporated. The exclusionary rule was saying that if there wasn't something explicitly stated on the search warrant, it couldn't be used in a trial, it has to be excluded, and states had to do that. Now that was in the 1960s with the Warren Court, where I had mentioned in plain view when we were going over this case. That is the Nix versus Williams, which if there's a search warrant and they come into the house and there's something that's not on the search warrant, but if it's on the kitchen table or something, that can still be used against them if it's illegal. Terry versus Ohio, another case we went into. This is where a lot of law officers like this, the idea that for their own safety, again, there's a different scrutiny. If they pull you over, they can search the car for their own safety. This is where for stop and frisk, and that's where it's come up a lot lately. Here's where you have to realize what the difference is they can with something mobile, reasonable suspicion, but for like a house, have the probable cause that you have. Recently that has been in a lot more about because we're New York City police officers, we're doing a lot more stop and frisk, happen to be a lot more brown people there, and they're saying that they were abusing that. In the actual Terry case, the officer will spend quite a while observing the people before he stops and frisks them. The other side of the Fourth Amendment is the penumbra side of the right to privacy. There is no actual word right to privacy, but the Supreme Court will end up using this in there. Two cases that we had were Griswold versus Connecticut and Roe versus Wade, in which the right to privacy was done. Griswold over consumption, Roe versus Wade went for abortion. Now, for the abortion itself, some cases you need to be familiar with. I know we discussed this with the cases, but this is where to be familiar with the idea, especially Planned Parenthood versus Casey. Since Roe versus Wade, the Supreme Court has allowed the states to make more restrictions or limitations. Key thing, as long as they don't do an undue burden on women. Probably the most common of this will be some waiting periods that we have. And we have organizations like NOW that will be fighting against this as states have made various things. A lot of this is due for that, especially in that time period, the second trimester, as when we divide up Roe versus Wade into the 3 trimesters there. Also, the idea for privacy has been in recent years with surrogate parents, homosexuality, different physician-assisted suicide. So this has been extended in other cases from that time. All right, our Fifth Amendment. Most people think of the Fifth Amendment as I plead the Fifth, and self-incrimination is one of the 4 parts, and you need to know all 4 parts of the Fifth Amendment. Our court case we had, Miranda, the very beginning of the Miranda warning is you have the right to remain silent, so this is where you are informed of your Fifth Amendment. Realizing here that if our legal system is designed that you are innocent until proven guilty, again, it is up to the state, which is the prosecutors, to prove the guilt. Second part of the Fifth Amendment is just compensation. Now you think just is fair, compensation is a payment. So the government is allowed to take away something from you. They can take your property, but they must give you a fair price. They can't just go and decide to build a highway, kick you out of your home. They will go and they will make sure again that they're giving you a fair price. Now this is called eminent domain. We also will kind of look a little bit and see how that sometimes is used even in a private way, like even here in Citrus County, where we had a trailer park in Homosassa that was on some very good waterfront, but then they will eminent domain, they will pay the people a fair price, they are force them to leave, and then they put condominiums and nicer homes there. And this is a issue that we have sometimes, that is not always for like a road or a school or a prison that you normally think in here. Again, the government is allowed to take your property, but they must use due process and pay you a fair price. Double jeopardy is pretty straightforward. You can't be tried for the same crime twice. I know this is where it gets confusing when you look at something like the O.J. Simpson case. Realize there is criminal and civil are two different trials. There's also two different levels here that you have. In a criminal trial, that jury has to say beyond a reasonable doubt, but in a civil trial, it is preponderance of evidence. One in government that we focus on a lot here is the due process. It's in the Fifth Amendment, and then it's repeated in the 14th Amendment. And hopefully by now you figured out the 14th Amendment comes up again and again and again here. Not just for civil rights, but this is where the due process, that is a part of a lot of these incorporated cases in here. It can be with both crime and property and civil cases. This is where our bureaucracies, our courts have to follow them. Even in the schools, if you are suspended from school, the most that our assistant principal can give to you is 10 days. After that, to be expelled, you have a due process. You go in front of hearing in front of school board members that you have. That's a fair trial or a formal hearing. There's a lot of things that are kind of included in this. Exclusionary clause, our self-incrimination, warrants, just compensation. This is where a lot of times people say, do we really need our 4th, 6th, and 7th Amendments, because the 5th Amendment and due process kind of covers all of it in here. So basically your rights when you are accused of things. The rights of the accused, though, include not just the 5th, but also the 6th and the 7th there. Now, I know when we did in the beginning of the year with our amendments, the 6th Amendment was seen as the speedy trial, jury trial, but it's deeper than that. And the key thing, remember, the 6th Amendment is that it's a fair and speedy trial there. Our 3 cases we went over that you must know, each one of those, Miranda, Gideon, and Escobedo. This is all things that are included in these amendments. And again, you see the 6th Amendment, the right to a fair trial, that we have. Our 8th Amendment, cruel and unusual punishment, excessive bells or fines are prohibited in here. 2 cases we have that sort of do with this, because they also have to do with the 14th Amendment with Furman and Gregg that we went over. In Furman versus Gregg, they didn't say the death penalty in itself was cruel and unusual punishment. It was when it wasn't being applied evenly. So that's where they made every state have to go and take away their death penalty and rewrite it. And then the states had to bring up to the Supreme Court, had them look at it. Gregg versus Georgia was the first time that it was allowed. Florida was not much long after. In fact, we were the first to get Old Sparky going again at that time. In the state of Florida, we have our law. If anybody is given a capital punishment, it is automatically sent to the Florida Supreme Court for review. The Florida Supreme Court will review it. If they believe there's anything that has to do with gender or race in there, they will change it from a capital punishment to life imprisonment without parole. They don't make you innocent. Again, they can just change the punishment side of this here. This is where we kind of have had a lot of cases with, should a minor get a death penalty, or people that are mentally ill, or that you have the death penalty, especially a lot of states, like recently Virginia no longer does the death penalty. Part of the problem we've had is now with some of the DNA testing, like state of Illinois, that at one time, well, close to half of the people that were sitting on death row were actually there wrongfully accused in here. So the 1919, we have a case there that was incorporated for the excessive fines. That was one that we talked about in the other section of incorporation there, where the idea that you had that when communities were impounding and using the vehicles for revenue. The 9th and 10th Amendment, there is actually extremely important. This is where a lot of our prenumbras come from. This is where the idea that you have for life, liberty, pursuit of happiness, the right to vote, all right, because it says that if it wasn't written in the first 8, doesn't mean that you don't have that right, and there will be some others that you have. The 10th Amendment are our reserve powers for our states. This is the one that back in Chapter 3 we went over majorly, and this is part for the federalism, also with your close reading for the 10th Amendment that you have. A lot of broad questions that you can kind of look at here and see. How does your individual right compare to the majority? That conflicts. I gave an example in class of how if a student was to cuss me out, even if I say, oh, that's okay, and all the students aren't unoffended by it. Well, you didn't pay to go to school here. So the majority of the people, which is mainly older people, they probably don't want their taxpayer money going to something where we do not have that kind of kind of rules against such behavior. What is conflict between civil liberties and the scope of government? This is something you see again and again. Your personal freedom and power for the government. It goes back all the way to Ben Franklin and discussing the Declaration of Independence. How much security do you want? Because you can be a lot more secure, but you're giving up your freedom. So how much are you going to give up with that in here? And then basically, if it's a right versus a right, like security versus freedom of the press, example of that was the New York Times versus USA case involving the Pentagon Papers. So a lot of the things that you look at, there are the ideas, and there are conflicts, and the Supreme Court ultimately is the one that has to determine what the issues of conflicts. That's why we went over a lot of these cases, kind of give them examples. Your textbook has something that has been more of a modern thing, because this is where we look at the Bill of Rights. It guarantees the rights for the people accused, but what about for victims there? And so that is something that it's looking at. Here's where the question that some people look and say is, do we need something more in the Bill of Rights? Is it outdated? Do we in there? A lot of people will point to the Second Amendment, but a lot of people will also point to the fact of for victims that you have. And another part that your textbook has that I hope that you, in your readings that you saw, there are a lot of crimes that are committed that no one ever even sees. I mean, you possibly could be trespassing there. So how many crimes are committed compared to what's reported? And then what's reported, how many actually get an arrest? And once they're arrested, how many does the government, the state, decide to prosecute? And if they do decide to prosecute, how many then are plea bargained down before and they never actually get to a trial? And if they do get a trial, how many of them will go to a verdict phase and get to guilty and actually get the punishment? And you see of actual crimes, probably very, very small amount actually go that whole distance all the way to the punishment that you have. You will see a lot of these in different free responses that you have here. Notice on this one, this is back when they were true essays in here, rights of criminal defendants, the First Amendment, privacy rights. Notice on here they're asking about based on specific and relevant Supreme Court cases. That's one of the reasons why we had so many of those cases in our past fail quizzes, plus other cases that we bring up.